Hi, my name is Eduardo Garcia. I'm an advocacy associate at Campus Progress. I'm here today with Marshall Fitz, the Director of Immigration Policy at the Center for American Progress here in Washington, D.C. We're here today to talk about the upcoming Supreme Court case hearing for Arizona's SB1070. In April 2010, Arizona passed a strict and broad anti-immigrant law that unfairly targets immigrants and communities of color in the state. The outcome of the case will impact how states and local law enforcement practice immigration at the local level and could have a very serious impact to the livelihood of immigrants and communities of color. Thanks, Marshall, for joining us. I want to start by asking you a little bit about this law and how it got to the Supreme Court. So how exactly did this law get to the Supreme Court?
We probably need to go back to 2007 when Congress tried and failed to enact comprehensive immigration reform. This has been an ongoing struggle from the immigrant rights community to try to get federal legislation that would resolve and reform our immigration laws. But in the wake of that failure, lots and lots of states and localities started trying to dabble in immigration policy. They tried to take matters into their own hands, and frankly, they ended up treading where they should not have gone. And SB 1070 was a comprehensive enforcement scheme that known by its title as attrition through enforcement. And the idea was to make life so difficult, so harsh for undocumented immigrants and their families living in Arizona that they would up and leave. And what we've seen is that initiative in Arizona has now spread to several other states. And now we've got Georgia, South Carolina, Alabama, of course, most notoriously, and Utah have all passed similar comprehensive enforcement schemes. The federal government, the Department of Justice, challenged the Arizona law, basically saying, Arizona, you've entered into our domain, you've gone too far, and this is not permissible for a state to do. This is the federal government's job, is to regulate and enforce immigration policy. So they filed a lawsuit at the federal district court in Arizona. The federal judge agreed with the Department of Justice and blocked 4 key provisions. The Ninth Circuit, which is the Court of Appeals that hears those cases from the district court, they in turn upheld what the district court had decided. That case now has made it all the way to the Supreme Court. The state of Arizona has appealed that ruling, and the court is going to hear arguments on April 25th as to whether or not the states, in this particular case Arizona, but whether or not states generally can engage in this type of immigration regulation and enforcement.
So when the court hears this case this month on the 25th, you mentioned that they're going to be reviewing some provisions of the law that other states have tried to enact in their states as well. So what are those 4 provisions? So
the 4 provisions, the first one is one that makes it effectively a crime to be undocumented in Arizona. And everyone has to understand that while it's unlawful to be in the United States without papers, it's a civil violation, and it's a federal civil violation. It is not a crime. And so the first registration-related provision effectively makes it a crime to be undocumented in the state of Arizona. The second provision that's under consideration and that the court is reviewing makes it permissible for state and local cops to arrest someone that they believe has committed a deportable offense. So you put a state or local cop on the street making a decision about whether to arrest someone who doesn't have a warrant against them based on a consideration that they've actually done something that would make them deportable. That's really a stretch. The third provision is one that makes it a crime to work. Now, it's again unlawful for employers to hire someone who doesn't have legal status to be employed in the country.
So currently those folks would be held accountable if they were to hire someone that was without papers?
The employer would be held accountable because that's what the federal law says. And they would typically be held accountable for a civil violation. They would have to pay a significant fine. And of course, if they were doing it systematically and intentionally, they could be held criminally liable at some point. But it's not a crime for the worker to be employed and working under federal law. And Arizona for the first time would make that a crime. And now the last provision is the one that is the one that's gotten the most notoriety, I think. It's the "show me your papers, please" provision, which requires police to ask someone that they reasonably believe is undocumented in this country to prove on the spot what their immigration status is, that they are lawfully entitled to be in this country. And if they're not allowed, then they are potentially detained until they can prove that. They are potentially arrested and thrown in jail until they can prove their status. So the reality is that the people that are going to be stopped are people who are walking or driving while brown and have an accent or otherwise appear to be to be foreign. And you know, those are the people who are going to be profiled, targeted, and subjected to this discriminatory treatment.
Right. Thanks, Marshall, for joining us.
My pleasure.